Now we're really going to get into some complicated details with regard to contract assignments and delegations. And this is a little tough stuff to follow. So let's see if we can go through it slowly. So first of all, let's look at what are called assignments. So assignment is a transaction where I may have rights that under a contract that you're going to do something for me. But what I say is, oh, well, you were going to do it for me. I'm going to assign that right to someone else. And they are going to be the assignee of this contract. And now, instead of performing it for me, you have to perform it for that third party. And all I have to do is demonstrate an intent to assign. I tell you, or I do something to suggest, do this thing for someone else rather than for me. And the assignment is effective immediately, and I can't retain any rights. I can't say, you need to do this for me and for my assignee, because then you'd be doing it twice. And I can't say, you owe me $100, give 50 of it to me and 50 of it to the assignee. I have to sort of get out of the contract. I assign the entire contract benefit to a third party. Now, I can condition the assignment on some act. So if such and such happens, I am assigning my rights to a third party. The most common of those is death. Right? So I am owed something by you, but if I die, you owe it to my son or my daughter. That would be a common assignment. Now, the person who owes the duty, the obligor is what that's called, that person doesn't have to consent to the assignment. So I can assign my rights, and the obligor has to give that duty to that third party. But I need to tell the obligor, which of course makes sense, because if the obligor doesn't know that, they can't perform the benefit for that third party. But it's important to recognize that I don't need to get permission from the obligor. That obligor already owes me a duty. I'm just assigning it to someone else. I'm giving my right to receive whatever that thing is that that person owes me to a third party. Now I can assign it, and then I can revoke, potentially. I could say, do this for my child, and then revoke that if I decided I didn't like my child so much anymore. But if it's supported by consideration, then it's irrevocable. So if somebody says, oh, I want that thing that you're about to get under this contract, I'll give you $50 if you assign the contract to me, and then I assign it, then we've got consideration, right? Because you gave me $50 in order to assign the contract to you, and then it's irrevocable. If I do it gratuitously and there's no contract, then I can revoke it until it's delivered to the assignee in writing, or I give something like a will or something to that assignee. The assignee also might detrimentally rely on the assignment. They might say, oh, I'm getting assigned this right, therefore I will take X, Y, and Z steps. And that also would be something that would make the assignment irrevocable. Also, obviously, if the obligor goes and performs the contractual duties for the assignee, you can't come back and say, oh, I didn't actually mean to assign it at all, do it for me. After all, that would not work because the obligor obviously has already performed his or her or its duties under the contract. So that's how assignment works. Now, when we're talking about assignment, we're talking about the person who benefits from some obligation, assigning that benefit to a third party. There's also the possibility that the person who has to do the act, the obligor, might want to delegate their contract duties to a third party. That's called a delegation, not an assignment. And when an obligor delegates duties, the obligor becomes the delegator, and the person who now owes the duty is called the delegate. So it's complicated language, but the idea is pretty simple, which is I contract and I agree under the contract to paint your fence, and you agree to pay me $500, but now I'm going to ask someone else to paint the fence for me. Maybe a subcontractor, maybe a friend, somebody. That other person is the delegate. And the obligee, which is the person who is paying the money to have the fence painted, has to accept performance from the delegate. But the person who was the original party to the contract is the one who's still responsible if the delegate doesn't do it. So to use my fence painting example here, you hire me for $1,000 to paint your fence, and I say, oh, okay, well, I'll get my friend to paint the fence. I can do that, and you can't stop me from having my friend do it instead of me. But I'm still on the hook if the friend doesn't do it, because I'm the one who contracted with you to do that. And the delegate may not be compelled to perform unless the delegate promises with consideration. So I can't just designate somebody to perform in my place unless I've somehow made a contractual arrangement with that delegate to do it, and that contractual arrangement, like all contracts, has to be supported by consideration. Now, the one exception to this delegation rule is if my particular skill was part of what was being contracted for. So if we're talking about painting a fence, pretty much anyone can paint a fence pretty well, almost as well as anyone else. So if I delegate my duty to paint your fence to my friend, no big deal. But let's pretend that it wasn't a fence, it was your portrait was getting painted. And you had hired me because I was the greatest artist in the state, and you loved my portraiture in particular. Well, if that's the case, then you've really hired me specifically to do that paint job, and then I can't delegate it, because obviously if I delegate it to someone else, it won't be the same job. It'll be someone else's portrait, it won't be my portrait, and you contracted for me to do the portrait. So in those specific cases where it's really a particular skill that's being contracted for, then you can't have a delegation. But otherwise, a delegation is fine as long as I remain on the hook for the delegate actually doing the work.